Greetings, everyone. So, in continuation with the previous lecture that Aman sir has taken with you, he has apprised you of what all subjects he's going to take. And in the end, he has also told you about the subjects that I'm going to deal with you. But only to give you a brief of it, the subject that I'm going to take are international law in paper one, international law. This is for paper one in law optional. You now are well versed with the fact that we have two papers in law optional, paper one and paper two. In paper one, we have although three subjects, but they are divided into two only: constitutional and administrative law. These are two different subjects, but otherwise, constitutional and administrative law is taken to be as one subject. The other subject is international law. So, in paper one, I would be dealing with one of the aspect of paper one, that is international law. The second paper, that is paper two, I would be dealing with a good deal of subjects. For example, I would be dealing with law of crimes. Secondly, I would be dealing with law of torts. Thirdly, I would be dealing with law of contract and mercantile laws. Mercantile laws. Although I would tell you that law of contract also comes under the major heading of mercantile law only, but this is how they have written it down. If we can see it here too, that this is the PDF that we are sharing right now in the background is pertaining to the 2023 notification of the UPSC. So the syllabus that we have excerpted out here, which we are dealing with in this slide, is from the 2023 notification of UPSC CSC. So this is how they have written the heading of the subject as law of contracts and mercantile law. This may be called as law of contract and other mercantile laws because law of contract is one aspect of mercantile law. These kind of clarifications will keep on taking while we are taking up with these we are taking up with the subjects, or whenever we are dealing with the subjects, particularly when the course begins. We have already told you in the introductory video that the course is going to begin on 8th of May 2023 for all those who are willing to take up the course and who are willing to uh, decide about the one of the optional being law optional while you give your while you write your mains. So the subject that I'm going to deal with you is paper 1 international law, paper 2 law of crimes, law of torts and mercantile law, in which we will deal with also law of contract. There are certain other laws also in mercantile law, such as Sale of Goods Act and Partnership Act and law of agency. Everything is included in mercantile law only. Negotiable Instruments Act, Arbitration and Conciliation Act. So these aspects are also the aspects of mercantile law. So I will be dealing with all those with you while we are going through the course. Right now, I'm only dealing with the subtopics and a brief introduction about those areas, what you're going to read in these particular subjects, so that you know that what is the way through which we deal with these subjects, what is the way that we have to uh, get the approach correct throughout the examination, so that right from the first day while we read the subjects, we know that till when we have to confine ourselves, what is the content that we have to create, and through that content how we are going to take care of the answers. One video we will dedicate to only how the answers are written, particularly in law optional subject, because there are several methods of writing answers in different law optionals, different optionals in CSC, and also there is a different approach that you that you keep while you write answers in other subjects. So every optional, or you may say every subject, has its own approach of writing the answer. So one topic particularly, or one video particularly, will be of answer writing in law optional. How do we deal with writing an answer in law optional? Because it is very important for you to understand one thing, that while you deal with this particular subject, the approach, the mindset is very, very important, that you have to keep throughout your classrooms whenever we are going to deal with the subjects. You will have to keep yourself awake with respect to those particular factors which are very important with respect to understanding of the subject and then creating the content properly. And out of that content only, then you will be able to understand that how the answers are written. So we will be talking about all those things in the upcoming videos. This is only for the purpose of understanding that what all you will read inside that the topic that we are dealing with. Because I would give you a disclaimer before I begin with telling you that what all these what all subtopics are there and how we are going to deal with them. One disclaimer that you must always keep in your mind is that these subjects are very vast. If you will start reading about them, you will see that there are several books, several commentaries, several references about this particular topic. Law of contract itself is a very thin bare act. We will talk about what is a bare act too. For all the non-law background students, they would be getting surprised about hearing these terms like bare acts. Bare acts are nothing but just the enactment of a legislature. I think this much you anyhow understand. Bare acts means the enactment of legislature. Legislature, you very well understand. Being a student of polity, you very well understand what is the role of legislature in our country. So legislature is responsible to make laws. Whenever the legislature make laws, when they receive the assent of the president, the bill converts itself into an act. The very language used for the purpose of making a rule in this country by the parliament for the Union of India and by the state for that respective state is known in legal language as bare act. So if you will see that the law of contract is having a very thin bare act, that means there are no much provisions written inside. However, if you will start looking towards the concept behind each and every provision written, the correct understanding of the definitions given, the correct interpretation and the concept behind every provision which is written inside that particular bare act, the the theory is vast. You will see that it is humongous. So it sometimes becomes an industrious task to understand and to even apprise the fact that how much we have to read out of that the gamut of that particular topic. For example, if we are dealing with what do you mean by acceptance? How much to be read about acceptance? Because what is acceptance and what are the dimensions of acceptance? What are the dimensions of communication of acceptance? These all things have to be skimmed properly. Now the key is the same. The key is how you prepare for UPSC CSC. Less is more. This is what we are going to do. We will understand that how much is important for us. This we understand or this we assess by doing a analysis of previous year questions. So if we see the previous year questions, we will be able to understand that how much we have to read. Otherwise, there is no abyss. I tell you one thing, the word sky is the limit is very true if you start reading law as a subject. However, if you see your syllabus properly, your syllabus is confined to certain subjects. For example, in law of contract, if we start from the law of contract, these are the subheadings that you have to read. That means you understand that where you have to confine yourself in this particular subject. Otherwise, they would have just written law of contract and the work is done. They're not doing that. They are giving you the subheadings because they want you to confine yourself to those areas only from which they will ask questions, or probably they will ask questions. So somewhere we understand that in law of contracts and in mercantile law, what are the others mercantile law? Because mercantile law, if you see, is not confined to only what is written here in the syllabus. Everything which is the aspect of mercantility, every subject which is the aspect of commercial intercourse in this nation is the subject of mercantile law. For what the legislature or the courts have created law in both the aspects. Whatever law you trace from the legislature and also from the courts that are with respect to or related to the commercial aspect of this country, is mercantile law. But then, would you read banking laws in it? Would you read insurance laws in it? Because they are also the aspect of mercantility. Would you read any maritime mercantile law? Not at all. Why? Because we have all the subheadings with us. So this is how we confine ourselves in the study of any particular subject. So sometimes this I'm telling you because sometimes you get into dilemma that law is very vast. How will we be able to read so much in such a short span? And for all the non-law background students, it becomes again a very big question that because we know nothing about that, will we be able to cope up with the particular subject? Will we be able to understand that what is happening here? Let me tell you my past experience. I've been teaching this from the past 4 or 5 years, particularly law optional. And more than that, I have been mentoring students from Pop Judiciary. And many of them have now become judges and many of them have become IAS officers. If not IAS, but one of the services in UPSC, they have cleared through this law optional. And there are several who have come in very good, they have come in flying colors. They have scored very good marks and have already attained top 100 ranks. So ultimately, you understand one thing, this is just another subject. It has nothing to do with you being a law graduate or a non-law graduate. Maybe there's an edge to a law graduate because of the fact that he is already apprised with the particular approach that you have to keep while you read law. But that is what this course will do for you. This is what we will do for you. If you start interacting, you will be able to know that what is that particular feature that you have to keep in your subconscious before you put your conscious towards the particular subject. So while you take facts, the way of taking that fact is very important, and that way we will teach you. So even for non-law graduates, it is not a big thing. Mind it, people who take this course, who comes and enroll themselves in LLB, the Bachelors of Law, they will be having the same thing in their mind before they join Bachelors of Law, this graduation course. That we know nothing about law. You don't know anything about law. That is why you want to take up this subject. That is what we will do here. You do not have to be a law graduate before you understand that what are the paraphernalias of these particular topics or what the law of contract would do. This is just a common apprehension that you will not be able to understand a professional course because you don't belong to it. I would say that this would be true of medicine, because there you need to have a certain sense of uh, scientific appraisement as far as biology or biology or chemistry or physics is concerned, so that you may be able to apprise with the structures or the terms, the terminology that are coming in that particular subject. But that is not required here. This is something which is based upon your daily life. Whatever routine you follow, you just have to observe that where is the law here. And once you start doing it, which we will do anyhow when we will interact with each other throughout the course. So ultimately, you do not have to take any extra pressure of getting into this particular course, because this is not about the profession. This is about feeling the profession, and this profession will always give you that edge. It will actually aid you out to learn about the theory and the practicality and the approach that is found within. You don't have to worry about all these things. So if we start seeing this particular subject, law of contract, you see that there are very less factors or there are very less subtopics that you have to read inside this particular subject. For example, you're only reading about the nature and formation of contract. That's it. The formation and nature of contract. That means the very basic of it. And if you see, the factors vitiating free consent is just an aspect in the contract. There are several sections in the Contract Act. Our main focus will always remain upon section 1 to 75. And even inside these sections, there are several portions which we do not have to read, because the syllabus does not allow us to go there, and the questions never come from those portions. So why do even we have to waste our time going inside it? And because we are only confined with nature and formation of contract, vitiating free consent, that means we know where to hit. And when you analyze your previous year questions, you will see that the questions are pertaining to these areas only. They are not putting any exception to it. They are not asking you from those areas which are not written here. So you will never be finding yourself unattended in the examination. There will be no surprise for you in the examination, so it is going to be very easy for you. Otherwise, this subject is very, very huge. You will have to read several aspects, several things inside it, and in several dimensions. So to understand or to go to that particular spot where you will find yourself satiated enough that yes, we have got what we wanted from this particular Bear Act. Now I am prepared enough to fight before the court or to argue before the court. Now I am prepared enough to counsel my client. This is not the approach, because we don't want to do that. Our approach is only to clear the examination. And for the purpose of examination, the correct content is to be created. And to create the correct content, you must be having that the correct approach to read that content. That we will take care. If in just you understand the correct approach plus the correct content. If you understand this, this is where we have to confine ourselves. Approach is very important. If you don't know that how to think about this particular provision, what legislator would have thought before putting these words into the Bear Act, you will never be able to understand that why they are saying such words, why this particular logic is appended to it. So the formula is very clear. Correct approach and the correct content. You understand this? Content we will create in the classroom, approach we will learn in the classroom. As simple as that. And what we are reading, nothing. Factors vitiating free consent, voidability, illegality, and unenforceable agreement. These are small aspects of contract. Small aspects. Quasi contract. What are quasi contract? Performance and discharge of contract. Consequences of breach of contract. Those of you who would have read it in the universities would know that this is nothing. And those who never have enrolled themselves in the law course or bachelor's of law, for them I would again just repeat the same thing, that this is something which can be taken care of only by understanding what is the correct approach, and you will take no years in understanding this. It is a matter of few days. Once we start with the subject, you will see that within 2-3 days you have actually you will get that grip upon that subject, because we will start with that particular approach and the content will be created. Your work is done. Now it is just the answer writing. And this is the approach we will keep with every subject minded, not just this. I'm just starting with this. The consequences of breach of contract, contract of indemnity, these are special contracts. After understanding what are the general principles of law in law of contract, because section 1 to 75 are talking about general principles of law in Contract Act, we will be going towards understanding the basic or the definitions of some specific contract, such as indemnity, such as guarantee, such as what is the contract of insurance. Now we are not reading about insurance laws. Insurance laws are not included in the subject, in the course. The syllabus only talks about the basic understanding of the contract of insurance, because it can be understood by understanding what is the contract of guarantee and what is the contract of indemnity. It is the amalgamation of both. So once you understand the basic of the contract of indemnity and of guarantee, you will understand what is the insurance. There is one aspect of contingent contract in the general principles of Contract Act. If you read that, you will be anyhow understanding what is a contract of insurance. Now we are not reading about what is IRDA. We are not understanding the rules and regulations created by IRDA. What are the functions of IRDA? We are not understanding about that. We just have to keep ourselves confined to the basic understanding of the contract of insurance. I'm not going to teach you here that what is a contract and how do we go about it, because we will have separate videos about understanding the topics, the excerpts of it, and rest of it we will do anyhow in the classrooms. Then again, a specific contract of agency. These are all these specific contract aspects of contract, and very basic, very easy concepts. Once you understand the general principles, they become very easy to understand. Then a specific contract of sale of goods, hire and purchase. This is what you will get in the entire subject. That's it. This ends here. And mind it, sale of goods is a different Bear Act. Earlier, it was the part of Indian Contract Act only, but it was taken out from there and a different Bear Act was created. For what purpose, we will see that. How it is differentiated from hire purchase, what is partnership, and see what it says. Formation and dissolution of partnership. That's it. They're not asking you to calculate about the accounts of partnership. They're not taking you into unnecessary areas. They want you to only get yourself apprised of. That means acquainted with the basic nature of these Bear Acts. Basic nature. So how hard it is to understand. After I'm done with dealing with the syllabus, I'll tell you that why law optional will always help you in your career. And that will give you a very clear picture that how you have to decide about the way forward with your optional subject. Why law optional is going to, everyone does that. I am just going to maybe deal with you in a different way, that how law optional will help you in your career and in future, wherever you are, with whatever services you are. Even if you become a clerk, mind it. I'm not saying that you will become one. Even if you become a clerk, even if you are a peon, how law will affect you and how the knowledge of law will always keep you in a better position. This is something which is very much to be understood by each and every one of you. Everyone means not just you, everyone who watches this video. Even the civilians must understand that how law is going to change the aspect of observation around them. Because there are several things that we do in our daily lives of which we may be happy to know about because we apply some logic to it on our own. But if we also trace a particular legality in it, how to trace that legality will make you more confident about taking your decisions every day. We will talk about it. Then what remains? Negotiable Instrument Act. Now, Negotiable Instrument Act in itself is a very big subject. But what we are going to deal with it here? We will only deal with the basic understanding of what is a negotiable instrument, what types of negotiable instruments are there, and then what is the aspect of breach of any negotiable instrument. That means if any negotiable instrument is not entertained or is not honored, what is the consequence and why that consequence is given in that particular Bear Act, in that particular statute. Bear Act is also known as statute. This you would be knowing. Another name for Bear Acts are statutes. That is why we call them statutory provisions, because statute is made through statute. Statute is something that is the law enacted by the legislature. And mind it, we do not use these words so colloquially that we can apply this to each and every aspect of lawmaking authority. For example, courts also make laws. But the law made by court is not known as a Bear Act. It is not known as a statute. It is known as a precedent, a case law. This is what is the difference. Whenever you use a term, you use it to its exact place, to its particular place. You do not mix up the terms. Otherwise, it will have a different meaning. And this will show that you do not have the particular approach while you talk about law or while you read law. For example, you just can't say that any law is withdrawn by the legislature will be called as struck down. It will be called as repeal only. If it has to be struck down, it can only be done by the courts. So every term has its own place. This also we will keep on understanding while we will do the subjects. So don't worry about that. So you understand, bare acts or statute, they are one and the same thing. We can use it for the same definition. And then Arbitration and Conciliation Act. These days it is in vogue. It is one of the most sought after legal remedy, which is one of the aspect of ADR. ADR you would be knowing, alternate dispute resolution. So it is one of the aspect of alternate dispute resolution because of the inundancy of cases in India. You would be you are apprised with the fact that there are around 3 crores cases pending in all the courts in India, including trial courts and in High Court and Supreme Court. So one of the way you alternatively decided to resolve the dispute in India is by way of arbitration and conciliation. Another aspect of ADR you will read under contemporary legal development, which Aman sir will take care, where you will read about the other aspects of alternative dispute resolution mechanisms. ADRMs is what we call them. ADR is alternate dispute resolution. That means it is a concept. And ADRM, M is mechanism. Mechanism means the means by which you will conduct an alternative dispute resolution. So other forms of ADRMs you will take care. In CLD. One aspect is Arbitration and Conciliation Act, that in slight detail we will discuss in mercantile law. These all are the aspects of mercantile law. Law of contract is also the aspect of mercantile law, but they have written the heading in a way that they are differentiating between the two, but there is no difference. Law of contract also is the part of mercantile law only, if you have understood. So we're not getting into the briefs of these headings. We only want to know that how much you have to read so that you have prepared your mind before you even choose this optional to be one of the optional that you're going to write in mains. This will help you to decide about your future course. I hope you understand this. What all other topics we have? If we see, just a moment. Just above the law of contract, we have law of torts. Now this is a different area that you would never have heard of. You would have heard of a contract. You would have heard of law of crimes, IPC, everyone would have heard of. Offenses, murder, theft. Everyone eulogizes these terms. They are very well versed with these terms since childhood. Everyone wants to know about the police, the arrest procedures, remand, although you don't know the difference between all. That is the aspect of understanding the nuances of legal terminologies and the way the general public uses them, because remand is not a loose term to be used everywhere. Arrest is not a loose term to be used anywhere. They have their own place and a particular concept with which they are to be attached. Although CRPC, these are the concepts of CRPC, we do not have criminal procedure code as one of the subject in law optional. However, while we read law of crimes, I'll keep discussing all these aspects with you so that you actually can apprise of all the aspects properly. Because through my past experience, I could tell you that whenever you say that we have opted law as an option in CSC, the board always asks you some questions which pertains to criminal procedure code. And because you do not have this subject in your syllabus, you will never read them. For all the non-law graduates, it becomes very hard to apprise. So, what is important here? It is important for us to understand that there are several concepts and aspects that we do not deal with that particular subject, but we must know. And all those aspects will be included. It does not mean that I will discuss with you the all provisions of CRPC in detail. It takes around 3 to 4 months, mind it. When I teach judiciary, it takes around 3 months, a 3-hour everyday class to finish that particular subject, confining to the syllabus, mind it. Again, analyzing the PYQs. Confining to the syllabus, I take so much of time because of the vastness of the concepts involved therein. So we're not going to do that. However, I will take you to all those particular areas which you must know so that you will be able to give your answers properly, and all those factors will not disturb you to not create your content the way it has to look. Everyone knows about what is the law of crime. Crime means whatever the offense is. Everyone knows about IPC. In Hindi, you call it as Bharatiya Dand Sanghita. Dand Sanghita. Indian Penal Code. Penal Code. Penal means penalizing. Penalizing is another word for punishment. Punishment is defined under Section 53 IPC as being a death. Whenever the death is awarded to a person, kill him. This is what you known as what you call as judicial death, or a legal death, or a statutory killing or statutory homicide of a person. Statutory homicide, statutory. IPC is a statute, it is a bare act. And there, the punishment is provided as death. That means the consequence of doing some act which is an offense will be death. I will kill you. Law will kill you. Law is saying that I will kill you. So ultimately, death is one of the punishment. Life imprisonment, you would have heard, is one of the punishment. Imprisonment is one of the punishment. Forfeiture of property is one of the punishment. Fine is one of the punishment. That is why it is known as Indian Penal Code, because it provides for the acts for which punishment is the remedy. Punishment will be awarded. The acts for which punishment will be awarded, and everyone knows about it. Actually, our society is made in such a way, if you have read sociology, the way we behave is how we inculcate our uh, future course. The behavior of society is such that they always keep on telling you about these facts since childhood. You've never read about them, mind it. You've never read about police. None of you would have opened Police Act ever. But you still know that the person having that khaki uniform is known as a police officer. Despite of the fact that he may be a normal private guard having the same uniform or the same colored uniform, although it is denied or it is barred, it is prohibited not to wear the same colored uniform. They can have a different shades and colors. However, how do you know that that person is a police officer? It is only because you are told and you are always apprised of this fact that this person who is wearing the khaki is a police officer, supposed to be a police officer. And then you know he's an inspector. Never know about you do not know about DSPs and SPs. Maybe you have heard about SP, but the name what you know is inspector. Everyone is an inspector. Police inspector. This is what you are told. This is how the society behaves. That is why you know about it. But you never have heard about the law of torts. If someone hits you intentionally, it becomes a crime. It becomes an offense. And the punishment is the consequence. The remedy that the law provides is that we will award punishment. We will punish him. But have you heard about the situation when a person is not intentionally hitting someone, but he has a duty to behave in a certain manner, and he did not do his duty properly, and he got hit by him? For example, when I tread in a lonely road, I may do like this. No one is going to stop me because it's a lonely road. No one is there around. However, you would see that when you visit Sarojini Nagar market or Karol Bagh market, you go to Karol Bagh market and you see that how you behave. If you are going to fly like a bird while you are walking on the road, while you're treading on the road, everyone will say one thing: Sir, kindly mind your act. Sir, kindly mind your walk. Why would they say so? Because now it becomes, because of this such situation, that it is a crowded place. There are several people who are treading the same path, and every one of them will behave likely. If you will not do that, it may cause injury to the other, because if you're going to fly like a bird, open wings, and your hands like this, everyone will get a slap here. I don't want to hit anyone. I am not doing it intentionally. I am not doing it deliberately. But I want to just do like this. But I have a duty not to do like this. If I don't do this duty, this is the duty of care. If I don't do this duty, someone may get injury. And if someone gets injury, he can seek compensation from you. Compensation means to recompense. The loss that he has sustained through this act, he can take some money out of you to recompense his loss. This aspect of law is known as law of torts. We will deal with the whole subject in the entire course. This aspect of law is law of torts. Nature and definition, again. Liability based upon fault, strict liability. All these are aspects of tort. There are certain overlappings also in this particular subject. Overlapping with what? Overlapping with the law of crime. There are certain acts which are crime as well as tort. But in tort, you can only take money as a consequence. In crime, you can take punishment as a consequence. If you want someone to get punishment, you have to approach with the law of crimes, where the aspect of intention is dominant. This is what we have to understand, how it is different. What is the aspect of this particular law? And you will see that there are several burning topics that you are going to read here. For example, recently you would have heard about defamation. Everyone is filing the suit of defamation. Recently, Nawazuddin Siddiqui has filed a suit of defamation against his brother and the ex-wife. How it works, what is defamation, how actually this particular concept behaves. This is what we are going to skim through, or this is what in brief, in gist, we will read in the entire subject. Defamation, a very important aspect of negligence. Then what are the defenses that you get while you bring a suit of tort, suit of these torts in this particular subject? What do you mean by vicarious liability? A very good example of this liability is that when a doctor does a wrong in a hospital, why you bring hospital in the court? Hospital would say that, management would say that, what is our fault? It is the doctor who did the negligence. Why don't you take him to the court? But along with the doctor, hospital is also dragged to the court. Why? The same reason. Vicarious liability is the reason why you drag the master for the act of servant. You see that what kind of vastness, and again uh, the burning topics that you are going to read inside these particular subjects, and how it will uplift you in your understanding while you behave in a normal way. You will now be able to understand that if any statement will be called as defamation or not, if any particular act will be taken as negligence or not. Your understanding with respect to any particular topic or any particular act will ameliorate. There will be an appreciation to your understanding, and ultimately the goal of this optional will be taken care. The goal of this optional is that you should stand apart in understanding of a particular act or a conduct as far as law is concerned, as far as the legality of it is concerned. Because tomorrow, when you will become an officer, you are not someone to not sit in a tribunal. Mind it, if you are an officer, and obviously an administrative officer, you are sitting in a managerial position. You're a class 1 officer. You're sitting in a managerial position. And being a manager, you have to manage things around. And one of the aspect of managing your operations is to also resolve the disputes. And this is how you will also sit like a tribunal, a quasi judicial authority, taking the disputes before you of employees inter se, or even if the, the public that you are dealing with, because all your work is about public dealing. So the public you are dealing with will have grievances, and you are the one who will sit over those grievances to decide upon them. And how to decide them becomes the major phenomena. How to decide, manner, how is very important. How to decide becomes the phenomena of legal knowledge. It is one of the aspect of legal knowledge, because how is what is regulated by the constitution. This is what you will understand by the principles that are enumerated in administrative law. And this is what you will understand while you understand all these aspects. Tomorrow, as a district magistrate, you will have responsibility to remove public nuisance from the district, whatever your jurisdiction is. And how would you know that if something is nuisance or not? One topic is already there in law of torts. You will very well understand that what is nuisance and how many types of nuisance are there. You have the power under CRPC to remove nuisance. How you will be able to understand that if a particular act is nuisance or not? Although you may get training about it, but the thing is that if you have already understood the base of that particular conduct or of that particular incident or event, you would be able to apprise that better. And you can always substantiate your training. This is how it will help you. Conspiracy, how a civil conspiracy is affected. The conspiracy that is talked about in torts is civil conspiracy, and the conspiracy talked about in crime is criminal conspiracy. So the conspiracy is also of two types, and both of this you will learn while you deal in IPC. You will learn about what is a criminal conspiracy, then the aspect of conspiracy. And mind it, you can only know about the aspect of conspiracy once you know what is the law of contract. Once you know about the aspect of contract, you will be understanding the law of conspiracy properly. Everything is interconnected. And that is how this approach will always give you a level up from the others. And this is how it will help you. The law optional will help you in shaping your career in a particular way. The fear that maybe I have taken a wrong decision will always wipe out from your mind. Why? Because you already know about it, that how to take that base, the basic structure of the basic. Everything has a basic structure. There's a basic structure to defamation too. The basic structure means the basic ingredients. You know about the ingredients. You know that I have seen all those ingredients. Only then I decided that this is defamation. This is nuisance. What else would be otherwise? False imprisonment. What are the aspects? Mainly what we deal in false imprisonment is illegal detention by the police, and also illegal detention by the private persons. But what we generally understand, that if we have to take compensation from police of illegal detention, we have to file a suit for false imprisonment. We must know what is false imprisonment. Malicious prosecution. If the prosecution is initiated and is carried throughout till the judgment with a bad intention, then you can take compensation for that too. Then what is malicious prosecution? Consumer Protection Act. This is the law of tort. And in law of tort, there is one aspect of tort in Consumer Protection Act also. That is why Consumer Protection Act is included in law of torts. Look at the vastness, inclusiveness, and the brevity of the syllabus. They have given you everything. They have included all important topics, and they are brief enough to only tell you that you have to read about the brief of it, theory of it. You're not getting into the practical aspects. how in a case of defamation, the defamation is proved properly. What all aspects are there in cross examination? You do not have to go into this. This is the beauty of the syllabus that they have set for you, and that is how you are more relaxed if you see in comparison to other competitive examinations related to law field. You have understood this? The Consumer Protection Act is a very good aspect. We will deal about it in a good detail while we discuss it in the subject in the course. One more subject that I'm going to take with you is law of crimes. Let's see what all subtopics you have here. General principles of criminal liability, mens rea, actus reus. What is the role of mens rea and actus reus? Mens rea is known as guilty mind. Mind is guilty, and actus reus is known as guilty act. Act is guilty. And that is how they want you to begin with in the understanding of law of crimes. See, how many of you would know about these two components, elements of crime? There are four elements to crime. These are only two. One element of crime is human beings. Another element of crime is injury. And there are two elements of crime which are very, very important and quintessence to the proof of any crime or to create any conduct as defined as crime, which is mens rea and actus reus. That means your act must be guilty and your mind must be guilty. And to make your mind guilty, it is important that every offense must show that you have a particular intention. आपकी एक particular intention थी, intention, deliberation. You wanted that desire, the consequence, the conscious state of mind. Everything will be discussed in this particular aspect because they want you to understand about it. They just don't want you to read about murder. They first want you to understand that how a crime is created at all. What is the thought process behind making any conduct as crime? That means what is the process behind making any conduct, or what is the thought behind making any conduct punishable? Why you want this man to be punished for this conduct? Because we want this to happen. We want this act to be considered as guilty. We want this mind to be considered as guilty because he intended to carry out a particular act and he intended to approach or to take out a particular consequence. I want you dead, for example. I want you dead. That is why I shot you. My desire, my consequence, that I want you dead, desire, so that you die. You are no more in existence. This is what we want to stop. And the law want me to understand this by awarding me punishment. And I have seen that in my act, there is a guilty mind, there is a guilty act. What is a guilty mind? What is a guilty act? What are the aspects of it? Everything will be discussed. Clear so far? So, law of crimes wants you to start with this. And this is how the approach is going to be made. This is what we were talking about, correct approach and correct content. Always remember. Correct approach plus correct content. And this is the key not to only the law optional, this is the key to every subject. Every subject, whatever you are reading. UPSC, no UPSC whatsoever. Whenever you read anything, It is the correct approach of that particular subject and the correct content that you make will always give you an edge over the others. And this is how strategically you can finish your syllabus well in time and can practice it so that the answer writing is good. And this is how you will have a good answer writing. अगर आपको करेक्ट आंसर राइटिंग अप्रोच भी चाहिए तो भी दिस इज इंपॉर्टेंट द सिलेबस always starts with a subheading nature and definition. This is what they want you to apprise yourself with. They want you to be aware of the correct approach with which you have to look upon this particular subject so that you can understand the subtopics easily, so that you can write your answers in a proper manner, so that you can have a little in comparison to the others, a little above you are little above them, a little, or maybe it may happen that you are way above them and you are scoring very good marks. And this is how you clear your examination. And this is how also it helps you in your career. So ye khali, it is not only for the purpose of clearing examination. This particular subject will always give you an edge in your career. I can be sure of that, and I've seen that happening, mind it. That is why most of the administrative officers, once they clear CSE, they approach to learn law. They take study leave to read law. Because this always equip them with the tools or weapons to fight properly, to decide properly, to do their task properly. This is a, you may say that this is a professional appreciation. This experience will always put you above everyone else and will leave a mark upon the work that you have done. So it will also create a history for you. What all things are there? Criminal liability, mens rea, actus reus, kinds of punishment. I've already told you how many kinds of punishments are there. Oh, we will repeat that, don't worry, in the course. So kinds of punishment, emerging trends as to abolition of capital punishment. This will be a very beautiful discussion that we are going to do in the course. What is capital punishment? Death is actually known as capital punishment. What are the aspects of capital punishment? Why you want it to be abolished, and why the Supreme Court said that we want to retain it? This you will understand by understanding the theories of punishment, which is not here, but otherwise I will discuss it with you when we will take classes. Preparations and criminal attempt. There are stages to the act which is known as crime. There are certain stages that the jurists have found out that there are certain stages while you do an act. For example, you start with the intention. When you frame your mind that you want to do something, then you start with preparation. This is what they want you to understand. What is preparation? Then you start with attempt. When you do the attempt, then comes the commission of the offense. That means it is said that the act is now committed. Act is over. And once it is committed and it is proved in the court of law, you get punishment. General exceptions. If you are charged with a particular offense, if you are brought in the court of law, having upon you certain, or the law is bearing, the law is putting upon you certain acts that you have done, what all defenses you can take saying that I have not done this? This should not be attributed upon me. What is the principle behind these defenses being made available to the accused? Accused is a person who is alleged to have done a crime, alleged to have committed a crime. Why you want these defenses to be with him? Why you want this defense to be taken so that he is absolved of crime? Mind it, if any of the defense is proved, he is acquitted. It is understood or it is taken as that he has not done this crime. This is a very beautiful aspect that we will learn. Joint and constructive liability, again, the aspect of tort. Abetment. If someone is asking someone to do a crime, that someone who is asking someone to do the crime is also a criminal for us. He will be also awarded a punishment. What a beautiful concept. Criminal conspiracy. Again, I've told you the conspiracies are of two types: civil, criminal. Criminal conspiracy we will read in the law of crimes, and the civil conspiracy we will read in the tort. So both the conspiracies you will understand in the entire syllabus. Then we have specific offenses to be dealt with. Specific offenses such as we will read about the offenses against the state, in which we will generally discuss about sedition. Everyone would be knowing about it because every government has used it as a tool of oppression, a tool of oppressing democracy, a tool of oppressing the fundamental rights of citizens. So there is a very good uh, war, a tussle going on between the fundamental rights and the law of sedition, and how to reconcile both. This is what we will understand in this particular uh, portion of law of crimes. Then offense against public tranquility, which is that what do you understand by unlawful assembly? When five or more people are considered to be a part of unlawful assembly, when they are making unlawful assembly. These concepts, don't you think that is going to make you more make you more strong about understanding a particular aspect of society? Whenever you are going out of this class after learning all these things, you will see the society in a different manner altogether. You'll start looking forward for all those aspects, ingredients in that particular section, if it is applicable in this particular group or not. For example, any assembly of five or more persons who are doing any of the objects which are written under section 141 is known as unlawful assembly. Now you know that which assembly is to be called as unlawful. Otherwise, we will also assemble in the class. There will be several people sitting in the class. This will not be this will not be called as unlawful assembly. And this is how you actually are more aware of things or acts happening around you. And what more do you want here being an IAS officer? Because tomorrow the responsibility of dispersing the unlawful assembly is upon an executive magistrate and upon a police officer, where the IPS will take the role. Tomorrow it is very important for you to even understand that what is the role of public tranquility and what all offenses are included in it. For example, there is a riot control unit in every police department, in every district. That riot control unit is what? Rioting is one of the aspect of rioting is an offense. And that is why you have constituted a riot control unit everywhere, because you want to suppress rioting. And what is rioting is given under IPC. Tomorrow, if you become an IPS officer, this law of crimes will always give you an edge to understand the content that is going to be provided you in the training in Sardar Vallabhbhai Academy. Getting this point? Again, we will learn about the offense against human body, such as murder, culpable homicide, the difference between the two. This is the most coveted topic in law of crimes, and very easy to understand. Offenses against property. Property means if you have money, money is a movable property. If someone takes your money, no one is harming your body. So it is not an offense against body, but someone is harming your property, because money is considered to be a movable property. So if someone harms or takes away your property, for example, if someone takes this pen away from me, that is known as theft. Then there is one aspect of extortion. Then one aspect called criminal misappropriation. One aspect called robbery, which is theft and extortion both. But of in a particular situation, theft and extortion is considered as robbery. And if there is a quantity, see the beauty of these crimes. There is one thing called theft, one thing called extortion. We will learn the difference between the two. And theft and extortion becomes robbery in a certain situation. Robbery is nothing but theft and extortion. Theft and extortion become robbery in a certain situation. And if you add number of persons here, it becomes dacoity. Look at the way you have to understand things. What a mesmerizing way of understanding law. You will be surprised, you will be stunned vis-a-vis getting acquainted with the perfect difference between all and the perfect interrelationship of all. This is what we are going to read in property. Then offense against women. This you understand that why offense against women are given, why there are certain gender biased offenses given in law of crimes. We will understand the approach, and also we'll read about the offenses that are offenses against women. Then defamation. You have already read defamation in tort, and we will understand that how defamation is defined under crime. That is why I said that tort and crime sometimes are overlapping. Look, defamation is the aspect of both tort. If you want to take compensation, if someone defames you, go to law of tort. If you want to give punishment to the person who defamed you, come to law of crimes. Prevention of Corruption Act, very important to be understood. Brief of it. We're not going to get into the unnecessary nuances. Brief of it. Protection of Civil Rights Act, and plea bargaining. Plea bargaining is the concept of criminal procedure code. But as I told you, I am not going to be confined to only the concept of plea bargaining in criminal procedure code. I will take you to all other differences and basic concepts which you must know to apprise law of crimes properly. So, not the bare act, but the few important concepts are what are important in criminal procedure code. You understood this. So see that how well we can take care of the entire syllabus. What remains in paper one I have with you is sorry. In paper one I have with you international law. Let's see what all is there. So international law, as you read law as a subject, international law becomes very, very important for you to also read. And mind it, they just don't want you to read about international law. They want you to understand the international committee, the relationship between nations. They want you to understand that how, because you read about international relations, you read about uh, international history, the world history, as you popularly called it. What is that? International means what is the international? The word itself will give you the glimpse of what we are going to read here. And then law. International means the law. International means that between nations, and law here means the legality, the legal connection between two nations. So international law. The name itself specifies the intent behind it. And why they want you to read it? Because you are reading about their history, you're reading about their commercial and other cultural intercourses, you are reading about their committees, you're reading about the regional associations that have been created internationally, because what you're all concerned with is to take care of your own nation. But mind it, as you understand the concept of Vasudev Kutumbakam, as in our country we eulogize, and particularly we are very practically using it as a concept of bringing the whole world as one, that we all are one human race. We should not discriminate against each other, we should not discriminate between us. All these aspects is what we are going to deal with as an approach to understand the topics given under international law. The legality of this approach is what we will read here, not the concept of Vasudev Kutumbakam as it stands, but yes, understanding that concept, that why it is said so that you understand the approach behind creating a law between the nations. Because we need a sense of legality so that we can. Why do we need law? If I ask you, why do we need law? We need law to regulate the behavior. This is what the purpose of international law is, that we are regulating the behavior between two nations. This is what we do. The world is comprised of different nations. They have to coexist. And if they have to coexist, not demeaning, not suppressing, or not discarding the existence of the other, we need to have some comity between us, a camaraderie between us. And if we put legality in it, it is going to be enforceable tomorrow. And if it is enforceable, only then we can be sure of that we all will coexist properly. The role of law can never be undermined. This is what international law does. And international law, all the aspects of legalities are dealt in this particular syllabus in a very brief and vast manner. Vast and brief, both. Everything is included, but everything in its own aspect. We do not have to again delve deep into each and every topic given here. Although the approach with which we are going to read international law is going to be always contemporary. That means whatever is the base, whatever is the concept, first we will read that, and then we will apply that concept to the present situation. That if there are certain cases or certain situations which are dealt with these laws, then we will be able to take it as an example and can deal with it properly. Nature and definition, as I've told you, will always give you an approach to the subject. Relationship between international law and municipal law. International law here is the law between nations. Municipal law means law of the nation. For example, all the Indian laws are municipal laws. Indian laws means all the laws made by Parliament of India for their citizens are in Indian laws. That in international law or in the regime of international law is known as municipal law. It is not the law of municipality of any particular state. Municipal law is the law of a particular country which governs their own citizens. And then international law, the law which governs the relationship of countries. State recognition and state succession. How do you recognize a state? Before that, we will understand what is the definition of a state. Who do you call a state in the regime of international law, in the whole area of international law? Beautifully, they have set out your syllabus, minded. What else do you want to know about? And once you know about all these things, how easy it will become for you to understand the world history and why this particular event has happened, even if you have, or why that particular event would have happened. How easy it will become, how facile it will become for you to apprise now even those areas of international relations which you would otherwise not have understood, but for this. Understand the role of law and how it is going to help you throughout. Law of the seas, very, very important aspect. The fight over water. We will see that water is filled with abundant resources. Man's desire are unlimited, resources are limited, and wherever the men will find resources, they will fight over it. We want to put a calm to that fight. We want peace. And you will see that international law is all about maintaining peace. It's all about peace. Law is all about peace. So international law is also all about peace. We have law today, that is why we are at peace. Otherwise, right now I am teaching you here, I'm recording this video, anyone would come here and put me out of the classroom. And I will be frustrated. Why? I wanted to teach, why you are doing this? There is peace in my mind that no one can do that because there will be dire consequences if he does that. Because law is putting that consequence upon him. That is the peace that I have. This is the peace that the international the states or international entities will have among themselves or between them, which is important. Individuals. And in the law of the seas, we will have several aspects, don't worry about it. And we will see it very beautifully. You will learn everything, mind it. There is no difficulty in understanding any of the topic. And you will see that the only method of understanding international law is to observe your neighbors. That is the approach that we will keep, don't worry about. Individuals, nationality, statelessness, human rights and procedures. How a nationality is imputed upon a particular individual, what are the concepts, theories, everything we will read here. Territorial jurisdiction of state. India can only legislate upon its own territory. India or Indian Parliament cannot legislate for the Pakistan. Can it do that? Not at all. So what India will do? India will legislate upon its own citizens, its own resources, its own international territory. That is what we will understand, that who are then going to be called Indian nationals. The concept behind that. Statelessness, how a person is known to be as stateless. That means belonging to no country. What kind of law we are going to impute upon him. All these aspects we are going to deal here. Territorial jurisdiction of states, extradition and asylum, the international jurisdiction of any state. Sorry, I went ahead, went with the previous topic. The territorial jurisdiction of the states, extradition and asylum. If someone has done some wrong and went to other country, we want him back in our country, extradition. If someone has not done any wrong and he wants a refuge in the other country, asylum. Simple. Simple definition, and you will understand that, oh, that is why you are saying that he must get political asylum. Oh, that is why they are saying that Nirav Modi should be extradited, Vijay Mallya should be extradited because they have done some wrong. That is why you're using the term extradition. Now, what a law graduate would understand here easily, which a non-law graduate would not do that. So it is very much discernible, very much comprehensible for all, irrespective of your academic background. Even if you're a non-law graduate, this is going to work for you. Don't worry. Treaties, how you form treaties. Treaties, if you will understand what is law of contract, you will very easily understand what is a treaty. Interrelated. See, United Nations. What is the role of United Nations? Why do you create this body, this legal entity? It is an international legal entity. It is responsible for several things. Primarily, it is responsible to keep peace between the countries who are members and also who are not members. We will see the aspects. Then, lawful recourse to force, if any country is using force, when he can do so lawfully and when he cannot do so unlawfully. If I am to defend myself, I will use my force. That is why it is known as defense forces. Defense, not offense forces, because no one is allowed to use force unabatedly. Rampant use of force is denied. If you are using it for defense, it is okay. That is why we call our force to be as defense. What are the aspects of it? Very easy. You will understand about it. Fundamental principles of international humanitarian law, legality of the use of nuclear weapons. What are the treaties that we have signed with respect to the use of nuclear weapons, non-proliferation treaty and all those things? We will skim towards it. We will discuss about them. And this will always apprise you of the present scenario of nuclear states and those who have uh, disdained the use of nuclear power as one of the tool of oppression or a tool of showing their metal or power in the world. We will discuss about all those things. Is a very important aspect, and also it will help you in world history, that how a nuclear power state is going to how they use their power for the purpose of uh, keeping peace, or they are using this power to only show that we can do anything we want. And very colloquially, we are going to discuss all those things, mind it. International terrorism, state sponsored terrorism, hijacking, everything is something which is a burning topic, current topic. You get your essays in language paper in these aspects. This aspect will always help you in preparing your essay properly, because terrorism is one of the forerunner topic uh, of essay in your language paper. New international economic order, monetary law. We will see that how economic sanctions work, what is an economic order, how economies are now fighting with each other, akin to a war. All these aspects we will understand in this particular area. Protection and improvement of human environment, very, very important as far as the surviving the existence of human race and survival of human race is concerned. The survival of territory and the existence of human race, how it is so important. So look at the subtopics that they have given to you. You won't find even a single topic not worth reading. And this is how it will help you to understand not just the syllabus of this optional, it will help you to understand all other things related in your syllabus properly. Everything will be entwined, everything will be interlinked, and ultimately you will see that how this optional has again put you above the others. We'll be coming up with short videos of certain topics, for example, from international law, from law of crimes, and the other teacher from his subject, so that you are more acquainted with the the pedagogy or the or the other methods that we are going to use for a better understanding and to have a good discussion with each other, so that we could understand that how we are going to help each other in apprising the course properly. The aid is for you to understand the syllabus, to understand the course, and to give your mains properly. And the aid is to us to also apprise that how we are going to make you better than the others. This is our motto, and this is what we are going to do. And mind it, I'll share with you our objective too behind this course, because this course is not only for the purpose of teaching you for this course, or teaching you for the law, for the optional, or teaching you to write mains answer properly. The very object in brief is to also help you throughout your career. And we are shaping a particular object to that. We are shaping a particular module to that. That if even when this course is over, how we are going to help you. Even when you have become the officer, you have cracked your examination, how even after that we are of a help to you. So this aid we will keep on delivering to you. So we are coming up with few short videos too in the near future, and there will be a frequency to it. There will be a consistency to it. We will look. We are looking forward for healthy interaction with you. Thank you so much for today.